Everyone, welcome back to the final session of Career-A-Thon series. I'm hosting this session after a very long time. So good to have you all here. Today we have none other than my first mentor in the corporate journey, Pranav Srivastava sir. My first corporate law firm internship I had done was with Phoenix Legal, and who better than Pranav sir to share his insights about career as a corporate lawyer. So since it's one of the most in-demand topic, we decided to keep it towards the end. And here we are today with us. So, brief introduction about Pranav sir. Sir, as you all know, is the partner at Phoenix Legal Delhi office, and he's also he's ranked by Business World Legal top 40 under 40 lawyers I think the global ranking they give. And sir is also the officer at YLCC International Bar Association. So we have received a few questions from you all based on the form we had circulated, and you submitted your queries in it. So on the basis of that, I'll start a few questions. Before that, sir, would you add anything to your introduction?
Samanika, hello everyone. I think you've introduced me, and I guess that's sufficient introduction. Just as a background, I think I'm a corporate lawyer. I work with Phoenix Legal. I'm a partner with the firm, and handle the firm's corporate practice. Large part of my practice is corporate M&A, but there is also a sort of bent towards a lot of M&A transactions in the infrastructure space, in power, in regulated sectors. So it could be insurance, it could be fintech, it could be financial services. A lot of M&A and investment transactions. And I guess there is a bit of I would say I'm a bit of a generalist specialist, which means that while I do a lot of corporate work, the corporate work spreads across, I think, different types of corporate work. It could be private equity, it could be venture capital, it could be M&A transactions, it could be corporate advisory. Yeah, that's just a brief introduction of me. Of course, as you may have noticed, I'm an officer with the International Bar Association. YLC stands for the Young Lawyers Committee of the International Bar Association. IBA is the most premier organization of lawyers around the world. It does host some conferences in India, but it's mostly an international organization and has international conferences around the world. I'm one of their officers. My job is to, as their officer, also sort of promote IBA amongst young lawyers in India. So that's just a bit of additional information about me. I guess Samanika had summarized it already, but just to kind of elaborate on some of those points.
Right. So, sir, I'll now take you through the questions we've received from the audience one by one. So, the first question is, what does a career as a corporate lawyer look like from a realist perspective? Because as glossy as it looks from the outside, is it actually true? How glorified it is in law schools, and the fact that NLUs also these days have such high fee structure that usually there's a corporate rat race which starts from day one, and then everybody is told how fancy the corporate world is. So from realist perspective, if you could highlight.
So I think glory is often the wrong reason why people choose corporate law as a profession. I think the realist perspective is that it is a profession that demands a lot more on your time, effort, and things like work-life balance, etc. At least in the initial years of your career. When I say initial years, it could mean 10 years, it could mean 15 years. It doesn't mean 1 or 2 years or 3 years. So even at 15 years as a partner or a senior partner in the firm, you're still very closely involved in execution of work, and it is very demanding on your time. And therefore, I think a recognition of the fact that it's a demanding profession in terms of time. Second, it's not a profession that everyone likes. Some people like to talk about politics, some people like to talk about business, some people like to talk about media, some people like to talk about movies. So you need to have that clear perspective of what is it that you like to hear about, what is it that you like to talk about, because if you fall in the trap of going towards a profession that is not to your liking, it is going to unfortunately constitute 80-90% of your life in terms of the time you will spend working and time you will spend doing other things. And therefore, if you end up on a side of practice which is not to your liking, it goes for all professions, but more so for corporate law, because it is a very time and effort demanding profession. If you end up on the wrong side because you thought that something is glorious and not necessarily aligned with your interests, then you may not have a good quality of life. And therefore, it's very important to realize that it's a very demanding profession. On the other hand, it is important to apply yourself to try and understand whether it is a profession which is meant for you. And the easiest way to do that, as you know, as law students, you have the opportunity to do internships in different types of different areas of law, and one or two internships in a corporate law firm would be enough to tell you what the corporate law is. And if the realization at the end of the internship is that that's not what you would like to do in the longer run, my recommendation would be that you look for something else. Because if you get attracted to or decide to pursue this career option driven by the glorified aspects of corporate law, which is maybe high income, fancy offices, etc., then you're not going to enjoy your life.
Okay. Next is, from the perspective of a law firm partner, could you walk us through your day-to-day roles and responsibilities? How does your everyday look like?
Yeah, so I think okay, as a partner, yes, there is a certain structure, but since most of the participants today are law students, I would try and elaborate more on, I think, also on what it would look like as an associate, what it would look like as a senior associate. So, I mean, starting from an associate. So when you are an associate, your day looks like nothing but waiting for your partner to give you instructions to do some research. At best, little bit of drafting of an email, perhaps, but nothing more than that. So it's more or less going to be waiting for your partner. Those are going to be long days. We'll start early, on time in the morning. We'll go until very late in the night. Often weekends will also get consumed on doing the work which has been instructed, not because the work is of that volume, but more because there is a steep learning curve which is involved in corporate law. You don't learn a lot of things in law school, and therefore in the initial years of your career, your learning curve is very steep, and therefore you're spending a lot of time in understanding what you have to do than just doing it. And therefore you end up, this gets kinds of end up eating into your weekends, ends up eating into your late night hours, etc. And therefore a day for a associate in a corporate law firm is more waiting for instructions and then executing those instructions, which are more or less going to be research in the initial years of your profession. Of course, if there is due diligence, then it may be reviewing some documents to identify certain issues, etc. But it's going to be limited to that. As you progress, let's say a senior associate or a principal associate, your work responsibility changes. In fact, it even changes from the first year to the second year and the second year to the third year, because the nature of expectation from you changes, the nature of delivery from you changes, and therefore the nature of work routine changes. But when you become a senior associate, the expectation is that you're delivering a work product which is 60, 70, 80% complete, which a partner can work on, or if you are a junior senior associate, maybe a principal associate counsel level lawyer could work on. So being able to deliver a work product and also manage the team, because when you are a senior associate or a principal associate, you would also be supervising a certain number of associates who would be reporting to you directly and indirectly to your partner. So therefore, as a senior or a principal associate, your work changes from primary execution to actually executing, delivering work products. And therefore, that's the change in nature of work. As far as your day is concerned, you're still more focused on execution. Other aspects of legal practice come into your domain as you step into the shoes of a partner. Coming to partners, now partners, the role is a lot more diverse than an associate. A lot of time goes in meetings, a lot of time goes in calls. So you're all the time in meetings and calls. Starting morning, you would have multiple calls coming to your landline, multiple calls already scheduled. You will have emails dropping in, clients asking for different things, and you will have meetings scheduled, which could be either work execution related meetings or negotiation meetings, or it could be even business development related meetings. Since your role now is split into multiple parts, so one of it which remains for, I think, most senior partners as well, unless you reach a managing partner stage when you start focusing more on firm management, it is execution of work or final product, or basically reviewing and finalizing. The second aspect is team management, which is hiring people, if required, firing people, training people, bringing them up to speed, making them useful for the client. The third aspect is, of course, business development, because there are two key aspects of a law firm. One is the client and one is the people. So you need client to get work, you need people to execute them. And therefore managing those two aspects. So therefore business development is a key role that a partner performs. And senior you become in as a partner, more your role responsibility starts moving towards business development and relatively lesser towards execution, because then you are potentially making partners under you. You're potentially working with very senior resources in the firm, not directly working with the junior associates, although we at least at Phoenix Legal continue to work with the junior most associates even as the partners. And but more of your time goes into calls, meetings, both business development as well as work execution, and then training sessions with your team, talking to your team, reviewing work product, finalizing work product. So your day just goes by doing all of those different things at different points in time.
Next is M&A and IP are the top two trending careers these days among law students. So what are the typical steps involved in an M&A transaction, and how can freshers prepare themselves for these responsibilities?
Yeah, I would add one more. I think litigation is the top trending career option amongst law students these days. I think in addition to, I think M&A and IP, because litigation, at least at the time when I started my profession, was not one of them. It has picked up in a very big way. So yes, M&A, IP for sure. IP also because India is moving towards a much more R&D focused economy than what it was. Earlier, it was mostly execution of work based on foreign R&D. Or even when foreign R&D comes into India, the protection of that IP is critical, and therefore IP is going to become more and more important. M&A, I think India has had a startup boom. India has had a boom in both existing big, large corporates are doing a lot more business. They are a lot more risk taking. They are going out. They are doing investments within India. And then you have foreign investors coming in on a much larger scale than what has ever been seen in India. And then you have a lot of these startups which are doing business. Therefore, M&A is a natural, consequence of a lot of business activity. When there will be business, there will be acquisitions and there will be mergers. The steps involved in a transaction, typically an M&A transaction starts with an initial discussion followed by a term sheet. Now it's going to be, you can call it a term sheet or you can call it a heads of terms. Some call it an MOU. Typically, it's a non-binding document, but it could be binding in certain situations, or certain clauses of it could be binding. But it typically starts with a term sheet. Once you have a term sheet, you would have an exclusivity period during which parties would only discuss with each other that transaction and not reach out to others. Then there would be immediately after term sheet, you would start work on different areas. One of them is going to be due diligence, which is due diligence, to put it simply, is an exercise of identifying risks. So it could be a legal due diligence, which we lawyers do. It could be a tax diligence, which tax lawyers or accounting advisors do. It could be an environmental due diligence, which environmental experts do. Legal aspects, of course, we lawyers do. It could be an IT diligence. It could be a technical diligence. It could be an anti-bribery corruption diligence. But basically an exercise of identifying risk. So that process starts. Simultaneously, the process of drafting and negotiating the transaction documents start. Of course, some of it links back to the outcome of due diligence, and therefore finalization of documents is not possible until you have the due diligence outcome completely. But the process already starts, and you are basically, one party would draft documents, the other party would review, give comments, then the lawyers and the principals will get on calls, negotiate the documents, and that finally leads to completion of due diligence, and negotiation of document finally leads to signing of transaction documents. Now, it depends on what is the nature of transaction. So if you're doing a share purchase, you will sign an SPA. If you're doing an asset purchase, you would sign an asset purchase or business transfer agreement. Depending on the nature of document, ultimately you'll reach the signing stage and you'll sign the transaction documents. Once you've signed the transaction documents, then is the process for the closing that starts. The first step is conditions precedent. So you may have identified certain issues during due diligence. For example, the business does not have a certain license, or there is a certain liability. Now you will split those issues that you've identified into different categories. The issues that should become conditions precedent must be resolved before we close the transaction. A license is not there, you need to go and get that license before we close the transaction. That becomes the condition precedent. Then the second is, there are certain issues which need not be resolved, but if there is a liability that arises, I need indemnification from the seller. And therefore, it becomes an indemnification point. So it becomes a specific indemnity. Then the third would be the issues which do not even meet the indemnification, because small issues, you may just cover them through your general reps and warranties, and they will get covered through general reps and warranties, do not call for a specific indemnity. And then there are fourth category, which are things which you are okay with being done later on. For example, some filing has to be done, which is not very critical. So you'd say, okay, fine, don't do it as a CP, condition precedent, do it as a condition subsequent within certain number of days of closing of the transaction. So these are the CPs. The CPs are to be satisfied. Once CPs are satisfied, there are certain letters exchanged between the parties, typically called the condition precedent satisfaction letter, satisfaction acceptance letter, etc., etc. Parties decide a closing date. There is a process called a disclosure letter, which means that the seller would deliver a letter setting out various disclosures it would make against various representations. Now, those disclosures would not result in a liability for the seller. So if, let's say, I've said you are in compliance with law, that's a representation. The seller may say, I'm in compliance with law. However, I did not file this form with the ROC in time. Now, if the seller has disclosed it to me, that will not be a indemnification matter. So tomorrow I can't make a claim against him to say, oh, you didn't tell me that there was this form which was filed, because he's disclosed it to me. Now it's my choice whether I want to convert that form, that risk, into an indemnification, or I'm fine with it being disclosed and not accepting that as a liability issue and moving on. So that's the disclosure process. After all of this, you reach the closing date when all the closing formalities are done. Now, closing formalities depend on the type of transaction. If it's a share purchase, then there are different aspects of closing. If it's a asset purchase, then there are different procedures that have to be followed for closing. Now, within share purchase also, if the shares are demat form, which is dematerialized, non-physical form, then there is a separate process that you follow with the depository participant, NSDL, CDSL. If it's a physical form, then you would do the typical share transfer form, board resolutions, endorsement of share certificates, and changes in the registers, etc. And that leads to closing. And then once closing is done, the deal is complete, the sale purchase is over, and then you will fulfill your conditions subsequent that you've agreed to as per the transaction document. So that's broadly those are broadly the steps of an M&A transaction. How can freshers prepare themselves for these responsibilities? I would say that, and this is a change that I have noticed, at least in my span of the legal career, which is that the preparation level has to some extent even gone down. I mean, there was a period when we used to hire young associates who, just after graduating, when they would join us, they would know what an FDI policy looks like. They would know what are the different caps and conditionalities. They would know what are pricing guidelines. They would know how an investment can be made by a foreign investor, what type of instruments can be issued. They would understand basics of company law. I think those are the things that we expect our freshers to know, not because they would have read. Some of them would have read it in law schools. Some law schools I know have started teaching things like FDI policy, but many law schools still don't. But you are expected to do a few internships, and the objective of those internships, and a lot of this material is in the public domain. There are a lot of organizations now which are providing some courses, etc., which can help you learn some of these. But the expectation is that you would know basics of company law, you would know basics of contracts, you would know basics of FDI policy, because these are the things that you would look at if you are going to become a corporate lawyer. And what you can do is try and do as many internships as you can. Once you've decided that you want to be a corporate lawyer, do as many corporate law firm internships as you can, not necessarily in number, but the period. I think a lot of people think that, okay, if I have Khaitan and I have Amarchand and I have AZB and I have JSA, then it's a great CV. It may not be a great CV, because that means 4 law firms looked at you and did not consider you for a placement. Whereas if you have 1 law firm or 2 law firms where you've spent considerable amount of time, that looks to me as a better CV. And therefore I think there is I think a need to understand that more time in one firm may be better than small time in multiple firms, because that just means you're internship hopping. But anyways, I think between no internships or less internships and many internships, certainly many internships are better, because that also shows that you've done made that effort several times, and you may have learned a few things. But if you, during those internships, please try and learn these aspects of corporate law, because this is the minimum a law firm would expect you to know when they interview you for a position in the firm. And once you join as an associate, the partner is not going to, while delegating work to you, start explaining to you what an automatic route under FDI policy means and what a government route under FDI policy means. So you need to be hitting the ground running somewhat, and for that these are the steps that you should be taking.
So the next one is, based on your experience, what are the common mistakes candidates commit during their interviews? This applies to both A1 to S1, SA1, and how can they mitigate these mistakes actually to increase their chances of selection?
I think the biggest mistake the candidates make when they so there are three things. I would think that if they resolve these three things, there is no reason why they should not be relatively successful in an interview. One is this overstate in their CVs. So they write a CV where they say, oh, we were doing something which they may have had a very small role on, and therefore not adequately describing their role, but in a broad brush stating what they have done. As an intern, you could not have advised on a deal. So all you can say is that, look, I researched on XYZ proposition, legal proposition. So as long as you state accurately in your CV what you've done, it will not give rise to uncomfortable questions which you will not be able to answer. Because if you write in broad brush, that gives a lot of ground for the interviewer to ask you questions, and ask you questions in area that you may not necessarily be prepared with. That's one. Second is to know your CV well. Now, if you've written something in the CV, you've said you've done this work, then I'm definitely going to ask you about that work. So, more likely than not, at least a few entries, I will definitely ask you if I'm interviewing you. And therefore, it is very important that you read your CV before you come for an interview. Read your CV, understand your CV. If something you've forgotten because you did a long time ago, either delete it from the CV or remember what you did. Refresh your memory, go back to your email, pull out the note that you had made, pull out the research that you had done, and refresh your memory and come with that fresh memory to be able to respond to questions if they are asked on any entry or anything that you've written in your CV. And the third and the most important, I think, of all is that there is an expectation from a fresher that you would know what you ought to know having studied in law school for 5 years. So if you come for an interview and you don't know what a contingent contract is, or what bailment is under Contracts Act, or what an agency is, or what are the essentials of a valid contract, or if you don't know a difference between a private company and a public company, or if you don't know what is the difference between the writ jurisdiction of the Supreme Court and the High Court, I think those are going to be red flags for any interviewer, because these are not things that we will teach you in law firms. This is something that we expect that a lawyer would know, because I would not be able to have a conversation with a lawyer of a work which is of a lot more sophisticated nature when I don't even know whether that lawyer has the understanding of basics of law. I mean, and these are not things that you need to do a lot of. If you've read your textbook, you would know these things. You would know answers to these questions. And a lot of time we come across people in interviews where they would not know what a contingent contract is, or what a essentials of a valid contract are, because this is when you start reading your contract law as a subject, the first thing that is taught to you are what are essentials of a valid contract. And I can tell you 80 to 90% people we interview don't know essentials of a valid contract. And therefore be thorough with the basic subjects. Now you can, if you're going for a corporate law internship, somebody will not ask you questions on family law unless you express an expertise in that subject. A lot of times they would ask you what are the areas in which you are an expert, what are the areas that you think you are your strong areas or your strength areas. And if you don't express family law, or you don't express even criminal law, you may not get asked questions on those areas. But at least read contracts, at least read sale of goods, read specific relief, read Companies Act. If possible, read a little bit of CPC Constitution, because those are certainly areas that will get used when you are doing corporate law practice. And then if you claim something, so if somebody asks you what is the strength area, anything, to avoid question on company law, let me say IBR. then please be ready with IPR, because even though the person interviewing you may be a corporate lawyer, but still they're far more thorough than you with even IPR law or criminal law or constitutional law than what you would expect. So there will be questions even in those areas if you express an expertise in those areas as against other areas which are supposed to be more natural for somebody who's aspiring to be a corporate lawyer.
Right. Also, sir, for SA levels, senior associate levels, what are the common mistakes do they commit?
So senior associate, I think, again, similar to what freshers do, but slightly nuanced. If you are writing deals on your CVs, a lot of senior associates would write deals. They would write that we acted on this deal. I think there is what we are looking for is not what deals you've done. We are not hiring a partner. We are hiring a senior associate and we would like to know whether you've, let's say, supervised a due diligence. And if you supervised a due diligence, what sections of due diligence did you look at? Not just saying that, oh, I advised, the HDFC bank merger. I mean, that's not something. If we start asking you questions in HDFC bank merger, then there is a plethora of questions you will not be able to respond to. So therefore, just be more accurate with your description in the CVs. Specifically mention that what's the nature of work you've done, and I guess again, thoroughness with legal law, thoroughness with an expectation from a principal associate or senior associate would be to also know a corporate law a bit better. So the expectation is that you know FDI policy. The expectation is that you know company law. Expectation is you know how deal closing is done, how a deal, how due diligence is conducted, what kind of issues you are supposed to identify when you are looking at, let's say, a transaction, let's say you're looking at a contract, what kind of issues you're expected to identify in a share purchase transaction. In a due diligence, when you have to verify the title on shares, what steps you take to verify the title on shares, depending on whether it is a demat form share or it's a physical form share. So those questions, which things that a senior associate is expected to do and demonstrates on the CV that he or she has done it, then certainly you should know how those things are done, because those would be the questions that will get asked.
Okay. How should one plan their law school journey to have a successful career? Because the common these days messages we see on LinkedIn floating is law firms have a bias towards NLUs and non-NLUs. So is it actually true? And how can one increase their chances of becoming visible to law firms?
So I think I'll start with the second point. I think law firms having a bias. Now, yes, I won't deny that there are various law firms that have historically had a little bit bias towards the national law schools. And the reason for that has been that the selection process, when you are hiring, let's say, 40 lawyers, is easier because they would go on a day one of a national law school selection or the placement process, and they would pick up the top 10, 20, 30 lawyers from each national law school, and that will give them a kitty of 70, 80 lawyers that they would hire in that year, or maybe 50 lawyers or 40 lawyers that they would hire in that year. However, I think so that's for the largest 4-5 firms. Then you have the tier 2 firms, the likes of us. We don't hire 40 lawyers, 50 lawyers. We may hire 5 lawyers, 6 lawyers. So we don't go for placements to various law schools. The way we select our associates is through the internship process. And since we are hiring a few, we are all the more cautious of their skill set. And I can tell you that more often than not, we end up hiring a non-NLU who's, let's say, the top 1% or top 2% of their batch, rather than NLU who may not be the top 1-2%. And at least this is my belief, and that's what I've seen in the period I have hired people for my team, that the non-NLU graduates who are in top 1 or 2% actually are better lawyers, more grounded than the national law schools. And the reason I say this is because, as a non-NLU, if you are a serious lawyer, if you are a serious law student, you know that you need to go through a different kind of a grind than a national law university lawyer. And therefore, the effort that you are taking, the number of internships you are doing, the number of the paper that you are writing, the number of moot courts that you are participating in will invariably be more than what the what a national law school university would have done. And therefore, a top 1%, 2%, 3%, we end up hiring more non-NLUs. However, we have also hired NLUs. The reason why NLUs get somewhat a preferential treatment is because, as I said, when you have to hire 20, you go for day one. If you go for that day one in a non-NLU, the quality of top 20 is not going to match a NLU. And the reason for that is that the rigor and the nature of their course curriculum is certainly, unfortunately, better than the non-NLUs. And while some non-NLUs are now doing well, they are trying to bring up their curriculum quality to the level of NLUs, and some have even outdone some of the NLUs. But despite that, I think the bigger firms, the law firms, are wary of going for day one hiring to non-NLUs because they expect more quality number of lawyers to come across in a day one hiring at an NLU. However, if you're getting through an internship, it does not matter. So if you are interning with a law firm, whether it's a tier 1, it's a tier 2, tier 3, if you're going through an internship, it does not matter. As a non-NLU, anyways, you will not have a very good placement day. And during your college will not be able to organize good law firms to come to your campus anyway. So it's better for you to rely on internships as the source of employment. And there, according to me, there is no distinction between an NLU and a non-NLU.
Right. Okay, so due to the heavy fee structure of law schools, students are seen running the rat race, as we discussed from day one. Most of them are not even aware of the roles and responsibilities they can expect in the professional world. And this also leads to high attrition rate. I recently had a conversation with a DSK Legal senior partner, Anjan sir, and he was also telling me that, Samanaka, I went to 9 colleges for campus placement. Almost every second person said, I want a corp job, but they themselves didn't know what comes under corp job or what does a corporate lawyer do. So, what is the right time? When should students pick their niche areas, and how can they self-learn beyond what is taught at law school?
See, just to put, trying to make it precise, although there is no one rule for, everyone, everyone has a different route that they take. But just to put some numbers there, I would say that first 3 years of your law school should be dedicated to doing internships across different types of practices. I think skip the typical NGO recommendation in the first year. Try and do, maybe litigation internships if you can. Try and do corporate internships. Try and do IP internships, and try and figure out where you want to land, what you want to finally pursue. By the time you are in your 4th year or middle of 4th year, you should have ideally figured out what is your area of interest. It doesn't happen always. A lot of times people figure out after 7 years into practice, but that's fine. But try to figure it out around 4th year. If you figured it out, then your final year internship should be focused towards that practice area. And that would more or less make sure that you will have an opportunity by the time you graduate, because you would have had time to do different things to figure out. And then you would have had some time to do a couple of repeated internships in your specific practice area to be able to find a placement early. Yes, knowing the roles and responsibilities is important. And that's why in the beginning of the session, I said that, it's important that you understand what your areas of interest are. You understand whether you like, like business law, whether you like corporate law. If you like corporate law, you ought to like business news. You ought to understand, or, you ought to have an interest towards reading what's going on in the business world. If your interest is towards something else, then, that's the nature of practice that you should be looking for. So if you are interested in corporate law, figuring out that is important. And if you've done that by, let's say, 3rd year or middle of 4th year, then dedicate the last 1.5 year towards doing internships only in that practice area, so that you can, by the time you graduate, you can land up a job. But having said that, there is no hard and fast rule. It could be that by the final year, you are still wanting to do litigation, but in the last month of your law school, you realize you want to do corporate. You can still do it. I mean, people have done litigation for 2 years and then started corporate, and done corporate for 2 years and then started litigation. So there's no hard and fast rule. But yes, if you can identify by the time you are in your fourth year, I think that will help you at least land the right place for yourself in the area of your interest by the time you graduate.
Okay, so the last part of the question. So, how can one self-learn beyond what is taught in law school? Like you mentioned, a lot of non-NLUs are still not able to match the curriculum or the grinding, as you mentioned. So, how can the students studying in those colleges self-learn?
So I think, see, self-learning, it's always, a lot of people ask that question, whether we should do more internships, whether we should do more courses, whether we should do more moot courts, whether we should do write more articles. I think what matters the most is whether you've taken that effort. And if you're taking the effort, you will be doing all four of them. The fact is that people who tell me that, oh, we didn't do moot courts all through our law school because we didn't like it or we didn't think they're useful, I think they've not uh, tried to understand what they are. I think they improve your writing skills, they improve your research skills, they improve your analytical skills, they improve your speaking skills, and therefore it's a whole round development. So if you, whether or not you want to become a corporate lawyer, I strongly recommend you do moot courts, as many as you can, because they train you for research, they train you for analysis, they train you for writing, they train you for speaking, all of the things that you will need to do even as a corporate lawyer. The second is internships, that you have to do internships. If you don't find a internship during June, July, figure out a way to do afternoon internship in March, April. Once you've done a few, you will find a June internship, because that's when a law firm will look at your CV and say, oh, they have a few internships on their CV and therefore this time I can give them. But if you want to have a vacation in June, then don't think that this vacation is not going to cost you. Unfortunately, it does in the initial years. I'm not trying to dissuade you from having vacations, but what I'm saying is that in the initial years during law school and initial years of profession are very critical for shaping how your career progression is going to be thereafter. And therefore, you have to utilize that time period to do what is required to be done in order to build a career. And one key aspect of it is doing all of these things. I would say, I would rate at least, one thing that I immediately look at whenever I get a CV is of a fresher is internships and moot courts. If that person has got a decent score, has done internships and has done moot courts, I think that's that CV is selected for sure. Now interview will do the rest, but CV is selected for sure. If you've done moot courts, if you've done internships and you have a good score, that CV is selected for sure. Not saying that those of you who have not done moot courts have stand no chance hereafter. That's not the case. But I'm saying that more moot courts do show that you have taken a lot of effort, and since you've done so much, you've potentially applied yourself on those moot propositions, and therefore how a research is done. But there is, as I said, there's no hard and fast rule. Those are my recommendations on what you should be doing when you are in law school, if you are looking to learn the skills beyond what you need to learn, beyond what is already taught in law schools, because unfortunately law schools don't teach a lot, and there is a lot to be desired and lot to be desired out of our education system, and therefore it's important that you do these activities to learn beyond. If you can do a few courses, it will help a lot, especially if you do courses where maybe people from the practice are taking courses on certain aspects of legal practice. That will not only help you do better as a young lawyer, but that will also help you even land up internships. That may also help you demonstrate your abilities better in an internship, and therefore become visible to the employers when you are interning in a law firm. If you have those skill set, then that goes a long way in being able to make yourself visible to the people who matter.
Right. If I may add one thing here. So, whenever you're thinking about moot courts and courses, the common trend I'm seeing these days is people are having the FOMO now, that if we don't enroll in a course, maybe we are lacking somewhere. But at the same time, they don't have that motivation beyond 1 week or 2 weeks to complete those courses. So, don't go for 10 different courses with 10 different brands. Rather, focus on one thing at a time, where you are able to focus on what is being taught. And most importantly, don't forget your basics, because people will talk about all fancy things these days about different domains, because I get to mentor on day-to-day basis. But when you ask them very basic things, like you mentioned, essentials of a contract or things like that, like hypothecation, lien, and they're like, we don't know that. So what's the point of learning fancy stuff when you can't have the basic knowledge?
Yeah, I mean, lots of times, we have lawyers or law students who come for interviews, and we ask them, what's your area of interest? They say, oh, our areas of interest are business laws. Now, business laws means what? I mean, you need to, or our areas of interest are banking laws. I mean, it means nothing. I mean, you need to, I'm not expecting you to tell me that you like business laws or you like banking laws. I just want you to tell me the act that you think you're comfortable with. Just say that, okay, I think I am comfortable with contract law, and then know what essentials of a valid contract are. Because if you say I'm comfortable with contract law and law, and then you don't know what a contingent contract is, then that's a red flag for any interviewer. So be
Right.
familiar with basics. We don't expect you to know uh, technical stuff. I mean, as a fresher, we don't expect you to know how you will do due diligence. We only expect you to know whether a contract, what will you see in order to determine whether a contract is valid or not.
Right. Okay. How fancy as compared to how they show in movies is the real corporate life? I think you've already covered it in the first question, but in one line, if you could also answer this.
No, so I think, see, of course, whenever you make movies, you show the entertaining parts of things, right? I mean, whether it's a movie on law or it's a movie on another profession, they would show the happy parts of it. So they will show, the Mike going for a fancy party and then in the morning going for a hearing, but they'll not show the night he spent in the
Yes.
library of the law firm, slogging himself, and the fact that next day he hasn't had sleep overnight and is going for that hearing without sleep. So there is some things which are shown. There are some things which are not shown. Not to say that, in of course, as a corporate lawyer, you will be in good offices, you will be paid well, you will have a chance to wear suits if you like, or wear at least formal clothes. You won't have to sweat yourself in the corridors of courts. You won't have to run here and there. The people you would interact with, the clients you would interact with would be mostly sophisticated people. You will interact with investment bankers, you will interact with merchant bankers, you will interact with private equity investors. So you will be talking to the creme de la creme of the corporate world, and you will be in that surrounding. But having said that, what really goes into corporate law practice is the hard work and effort, and these shows won't show, because of course it doesn't make sense to show something boring in a entertainment program. So that's hidden, but the rest of it, I would say, why not? Some of those things that they show are true. We do wear suits, but some of the things that they don't show, you ought to know, which is that the background to that is a lot of hard work, lot of slogging, a lot of nights that go without sleep, a lot of weekends, and a lot of family programs that you miss. So all of those things are in the background, which often get hidden in the movies that you see.
Okay. What are the possibilities of lateral shift in M&A sector? Are firms willing to hire non-law firm background professionals for the domain?
So if you, I mean, from purely from a M&A perspective, if you are a 1 or 2 year lawyer who's done something else, you want to join M&A and you apply to a law firm, you can be hired, although your experience may get discounted completely and you may be seen by the firm as a fresher. Eventually, if you perform, they may give you back your experience, put you back on your experience level, but mostly they would not consider non-corporate experience as relevant for their hiring. And on the other hand, if they find an equivalent 2 year corporate law experience lawyer, they will go for that. 6, 7 years, 8 years into something else, it becomes difficult, because the reality is it is a very time consuming and a profession which requires a lot of effort, and the amount of effort and dedication that you can put into it in your 20s, it's very difficult in 30s. So if you're going to move into your 30s doing something else and then think that now I'm going to go to a corporate law firm and going to start from scratch, it becomes a bit difficult. If you are looking for like the top tier firms, if you're looking for a smaller firm, a smaller this thing, you can make an entry from there and then eventually rise up the ladder. But the process becomes a little bit difficult, because you're competing with people who may be 5 years junior to you in the profession, but they are 2 more years experienced in corporate law. So it adds to complexity, difficulty, which is natural for whenever you make a shift into something new. But having said that, it's not impossible. Even at 7 years, if you want to make a shift into corporate, it is doable. But you ought to have the right frame of mind, that you won't mind a 5-year junior lawyer to you who has 2 years of more corporate law experience than you being even supervising your work. So as long as you have that right frame of mind, it's not impossible. It can be done.
Okay. So, my this question even I wanted to ask. So, you had become the partner, one of the youngest law firm partners within just 6 years of experience, and I understand that you're a first generation lawyer. So, what has been your motivational factor? And as a young partner, what is your secret style of leadership? Any tips you can share to how people can keep the morale of their team?
So I think, see, yes, I did make a partner early, and yes, I am a first generation lawyer because my father is not a lawyer. My grandfather actually was, but he wasn't around when I became a lawyer. But the what I guess helped me the most through the course of my career is a strict boss. I think if you find a difficult partner to work with, if you find a difficult boss, he's certainly going to bring you up. So a lot of times what feels uncomfortable is definitely good for your growth. And if you have a boss who's willing to put in effort in training you, in closely monitoring your work, in ticking you off when required, in telling you what you've not done right, in being hard with you when it's required, I think that goes a long way. And I think that's something that has worked for me as well. And I've had very difficult initial years with a very difficult boss, but it's worked in the longer run. And I think if you get a good mentor, if you get a good senior who may not be pleasant, but what is hardworking himself and is putting a lot of effort in training you, I think that's the best that can happen to you in your early years of profession, whether as a corporate lawyer or in any other profession or any other stream of legal profession. I think that's the number one, according to me, factor that helps you in your growth. A good boss, a good mentor, a good senior. Uh, and again, for me, I think again, I've even though I've been a partner now for over 5 years, uh, I'm very closely involved in execution of work, and I think that has two benefits to it. One, I believe that as a partner, you cannot demonstrate to your clients why they should hire you if you're yourself not involved in actually executing the work, because one, it keeps you up to date, and second, the clients are looking for the partner's experience, and therefore you need to pass on that to your client. So continued involvement in execution of work, and not completely moving away towards business development and firm management and those aspects of legal practice. That's one factor. And also, what helps you keeping with what helps you also interact better with your team is if you're yourself involved in the work. So no team would want to report to a partner who they think is not working himself. So it's very important that that messaging is very clear, that while whatever work we are doing, whatever we have to deliver to a client, it's an outcome of teamwork. It's not that there's an entitled partner who thinks that everything needs to be done by the team, and the partner himself is completely away from work. So being actually involved with the team and continuously working as hard as the team, if not more, I think those are the two key factors that one, help you as a partner in building your practice and remaining a competent lawyer, and second, it helps you also maintain a team and helps team realize that it's not only they who are putting in the effort, putting in the time, even the partner is putting as much hard work, even though that person has been working for so many years already.
Okay. So, since M&A overlaps with so many different domains like taxation, employment, and competition, how do you work with other legal professionals for the M&A deals?
So there is, and that's the reason why I generally tell young lawyers that please don't try to be specialized very early, because when you join a law firm, it's actually better for you to work across teams. Some firms have a policy of shifting people from team to team for initial years. Some firms don't have that, but since they are relatively smaller firms, lawyers end up working with multiple practice areas. So when you are a corporate lawyer, while you are not expected to know how to do number crunching in taxation, you are expected to know taxation to some extent, because if you don't know taxation at all, then you can't structure deals. Similarly, employment, competition, all of these areas you ought to know as an M&A lawyer as well. Having said that, yes, you may be working with specialists. That depends on the deal size. In certain deals, you will have the big four accounting firms as the tax advisor. You may have a separate accounting competition team advising on the competition aspects of the deal. There may be some deals where there is no one, and the expectation is for you to do that, and a tax lawyer may get involved for limited tax aspects. But generally, you are structuring it broadly also from a tax perspective. Even on big deals, when you are structuring a deal from a legal perspective, you can't put forward a structure which is completely not workable from a tax perspective, even though a tax lawyer is going to look at it, because then they will think that you don't have experience of how deals are supposed to be structured. You ought to understand the some broad nuances of taxation, broad nuances of employment issues, broad nuances of competition, and only then you can be an M&A lawyer. So as an M&A lawyer, you know all of these. On the other hand, at the same time, you also work with specialist legal professionals, depending on what the deal type is. And then you may be working with a competition team. You may be working with employment lawyers. You may be working with tax lawyers or tax accounting advisors. But that's on a need basis.
Okay, right. So now we'll open the forum for questions. Anybody has any doubts, you can start asking, and I'll stop sharing the screen. Yes. So if you have any doubts, please feel free to raise your hand. I'll question from Soumya in the chat box. She said, "What is the difference between an M&A attorney and someone who chooses M&A but belongs from the finance field?"
So there is, there are different advisors who are involved in an M&A transaction. So you could have you have M&A lawyers who are basically people like us who are advising on the legal aspects of transaction. You have M&A advisors from the finance side or commercial side who are people who are advising on, let's say, what should be the purchase consideration that should be paid, what multiple of EBITDA should be the purchase consideration, how should it be structured, what should be the earnouts that should be payable over a period of time. Then they will also assist in due diligence, finance due diligence, looking at the financial accounts, looking at the balance sheets to determine whether there are some items there which can reduce the value of the business. So what we do from a legal side, identification of legal risks, they are the ones who identify the commercial risks or the finance related risks. And similarly, you have other advisors, you have environment advisors, you have tax advisors, you have IT technical advisors. So you have different types of advisors on a deal who advise on their own different aspects of the deal.
Okay. Jashan, you had raised your hand. You can unmute yourself and ask.
Is currently I'm in my third year and I'm looking for summer internship specifically in M&A area because I'm interested to learn about it. But since I'm facing a lot of rejection, so what elements should be there, or how should I show my interest to the recruiter that yes, I'm interested? Because they expect me to have some kind of experience or some type of experience. I have corp litigation internships experiences. In IPR I have experience, but I don't have a general corporate or a corporate experience. So how to go about it? If you can guide me.
So Jashan, when you apply for internships, there are different periods, right? So you have a June and you have a July when the whole world is applying for an internship. I'll tell you from my personal experience. My corporate law internships, initial corporate law internships, were in the month of March, and I had to take some leave and manage my not all the leaves were consolidated at one point in time. I took them to do an internship in the month of March because I was not getting an internship in the month of June. And that becomes a challenge. I think it's a challenge universally. Law firms have limited slots. They can't accommodate the entire law schools in just 2 months. And therefore, this challenge arises. So where you can try and get a M&A internship in the month, which is not a very busy month, which may mean that you may have to have a discussion with your law school. You may have to have some work around for your leaves, or you may want to do a internship during post work hours. Or if for you the only option is June, then perhaps start with a smaller corporate law firm first, so that once you've done work, then in the next round you may be able to get a better internship. But because otherwise, if you were to directly write to a tier one as a third year student, because a lot of tier ones will not even take third year, they will expect you to be a fourth or a final year student. So as a third year student, if you are writing to a tier one law firm with no corporate experience, the chances of rejection are higher. If you were to apply in a March or in April, the chances will be lower, and therefore, you have to either work around with the timing, or you have to work around with the type of the law firm. You may have to go to a smaller tier.
Sure, sir. Thank you so much for your advice, sir. Because actually, we lack support from law schools, the corporation, attendance issues. So we are also willingly to work off beat, plus other reasons. But surely I will work on it, sir. Thank you so much.
I face the same issues, Jashan, and I think that's unfortunately what you have to work around with. So there are certain restrictions at both places, and I think but unfortunately that's the only way. And once you've got one or two corporate internships on your CV, it will become much easier for you to bag further internships.
Right. So there are two more questions. I had permission from you till 8 o'clock only. We have 2 minutes. So if you could pick any from the chat.
How does one as a law student learn about structuring deals? What are the resources one should refer to? So, of course, there is a lot of public domain material. You can ask Chat GPT, for example, but there are other ways. There is a lot of material in the public domain that you can access about what are different types of corporate transactions, etc. At the end of it, the learning will be during your internships. You won't be able to do a lot, but reading is important. There is a lot of material online. Different law firms write articles. Both Indian law firms as well as international law firms write articles about how different deal structures, different investment structures, how different rounds of fundings are done in startup environment, how different M&As are structured, with different shareholdings, how M&As are structured, how asset deals are structured. So a lot of material is there online. It wasn't there earlier, but now if you just try and Google some of it, you will find a lot of it online. And just try and rely on things which have been published by reputable firms, because then the chances of errors won't be there.
Right. Somebody is saying they've done a LLM in financial regulations, but the previous 2 years experience was in matrimonial matters. So how can they enter the corporate sector?
So I think if you've done an LLM in financial, what did you say? You have done an LLM in what, financial?
She said financial regulations and wants to enter banking and finance sector only.
Right. So there is, of course, you will have to, unfortunately, or 2 years of litigation experience may not be recognized by a banking finance lawyer. So they may look at you as a fresher, but apply to banking finance lawyers, and you can apply for fresher positions for now, because you will mention your experience. They may not take you at your PQE2 or PQE3 initially. They may take you at PQE0, but over a period of time, they may, if you are performing well, they may give you back your experience as per their firm policy. So I would suggest that apply in banking finance teams. It's a switch you want to make from litigation to another area of practice. LLM helps, but not really. It's not the key thing that most lawyers are looking for. Most lawyers are actually looking for people who are there willing to work hard. And of course, your LLM shows that you have interest in that area, and therefore, if you apply to a banking finance partner, I see no reason why that should not be an area for you to work on.
Right. So one common question: any particular book you could refer for the beginners to start their career?
So, there is to start their career, I think I would suggest the famous book called The Bear Act. And if you read that properly, I think there is nothing else you need to read. Just to understand how deals are, what corporate law practice is, I would suggest you read online material and focus on your Bear Acts. There is no other textbook, etc., that you need to read.
Right. So Manisha has been requesting me in chat to allow her to ask you a question directly.
Sure.
You can unmute yourself, and this will be the last question. Yes, Manisha, please go ahead.
Am I audible?
Yes, you are.
Yeah. Good evening, sir. Sir, I just want to ask, various people simultaneously do, along with law, company secretary course also, which is more and less related to laws only. And so when we go for internships, so whether it will be considered as one of the advantages over the internships. Like some people don't have that much of internships, but have an additional degree. Which is inclined towards specifically telling, yes, these are people who are actually inclined towards corporate laws only. So whether in some sense it will be an additional advantage because that person doesn't have that much of internships in the
Yes.
CV. That matter for only 7 or 8.
Yeah, I mean, 7 or 8 is not less. If you have 7 or 8 internships, I think it's a lot of internships. But having said that, I think if you have an additional course like the company secretaryship, which is not a simple course to just graduate, or not really a certificate course from some private school, yes, it will certainly help. More things are always better, but I would say that don't miss out on internship opportunities for a course. Internship opportunities are always going to you have a limited period of time before you graduate from law school, and you have to utilize that limited period of time in the best way possible. So I would suggest as much time you can dedicate to internships, do that. Then if you can manage beyond that, you can manage a course like company secretaryship, I would suggest you do that, because it certainly is positively seen on your CVs.
Right. Thank you so much, sir, for taking our time today. It was a really insightful session. I've had a lot of interactions with you in the past on different topics related to M&A, but we could never capture a full-fledged perspective on career related to corporate and M&A. So thank you so much for taking our time today. And anything last tips, sir, you would like to share with everyone?
No, I think as I said, it's a profession that requires a lot of effort, and the way it works for effort in life is that the little efforts that you will take over a long period of time will work like the ripples in the sea that translate into waves and sometimes tsunamis. So just keep taking small efforts over a period of time. It will translate into a lot of success.
Thank you so much, sir. Good night, everyone. Good night, sir.
Thank you.